Good morning, everyone, and thank you for joining us for our webinar this morning on workplace drug testing and marijuana legalization. This is Michelle Montoya. I head the compliance department at Filice Insurance, and we're really excited about this event today and its popularity. We have over 600 attendees, so pretty large group. Some of the things that we're going to talk about this morning. All right, I'm having a little trouble clicking here. All right, one second. I'm having a little technical difficulty. There we go. All right, sorry about that. We're having a little bit of delay on the slides. So we've got three presenters here this morning. Deborah Hyde, she's with Filice Insurance. She is our ERISA counsel. She's going to talk about the legalities this morning of drug testing. I'm going to talk about best practices and putting together your policy. And then we have Dr. Lana Burkhead joining us from Physicians Medical Group to talk about the technicalities of drug testing. So our agenda today, basically those three items. A couple of housekeeping things before we get started. First of all, like I said, there's 600 attendees, so there's no volume to ask questions. There are some widgets at the bottom where you can ask questions. There's a Q&A widget. There's also one that says help if you're having any trouble hearing the presentation or that sort of thing. Someone will jump on. And there's also a resource button. So after the event, there will be a PDF available to download the presentation slides. That's actually there now. We also have a couple sample policies that we're going to make available to you. So you can either get them during the event or after. We'll email them out. Finally, if you have any questions, feel free to submit them using the Q&A. And we're also going to take a few minutes at the end and use up as much time as we can with any remaining questions. And those that we don't get to, we will answer via email. So with that, I'm now going to turn it over to Deborah, and she's going to start us off talking about the law this morning. Thank you.
Thanks, Michelle. The foundation for our discussion this morning is the law, both in regard to marijuana use as well as to workplace drug testing. So let's actually start at the state level and take a look at California's laws regulating marijuana use. The medical use of marijuana has been legal in California for more than 20 years now. The Compassionate Use Act in 1995 legalized medical marijuana in the state, and this gives patients and caregivers the ability to grow, possess, and use marijuana to treat serious medical conditions, including but certainly not limited to AIDS, arthritis, cancer, seizures, severe nausea. The guideline for a medical condition to qualify for marijuana use is really that it be chronic and that it prevents the individual from carrying out one or more major life activities as defined in the Americans with Disabilities Act. To use medical marijuana, an individual does need to have a recommendation from a licensed physician. And there is a voluntary user registration program called the Medical Marijuana Identification Card Program run by the state. And this provides ID cards to individuals, basically identifying them as a patient who is eligible to use medical marijuana to treat a serious medical condition. That registration does need to be updated and renewed annually. But again, it's totally voluntary. There's no requirement that an individual register in order to be able to use medical marijuana. In addition to California, more than 30 other states have laws that legalize the use of medical marijuana. So it's definitely something that is gaining prevalence. More states than not legalize the use of medical marijuana. In addition to medical use, California just last month legalized recreational marijuana. So voters passed Proposition 64 in November, and this allows individuals aged 21 or older to possess limited amounts of marijuana for recreational use, and it permits the cultivation of up to 6 plants. However, really big caveat here is that the sale of marijuana for recreational purposes cannot legally take place until licenses are issued to dispensaries, and that's projected to happen around January 2018. So what this means is that at this exact point in time, recreational use of marijuana is legal, but the sale of recreational marijuana is not yet legal because that's pending future licensing regulation. So it's kind of an odd catch there. A handful of other states have adopted measures that legalize recreational marijuana. So we're looking at Alaska, Colorado, Maine, Massachusetts, Nevada, Oregon, and Washington, along with the District of Columbia. So while it's not nearly as prevalent as the medical use of marijuana, it is certainly gaining. Unlike California, federal law has not moved toward any level of legalization. Currently, marijuana remains illegal, both for medical and recreational uses. Under the Obama administration, the federal government refrains from interfering in states that legalize marijuana so long as those states implement reasonable regulations and practice oversight. So under this informal policy, the Fed basically choose to focus on higher priorities rather than pursuing smaller cases in these states, and those are cases that those states deem legal. So they're really not pursuing these smaller legal uses within these states. One issue and question that comes up quite a bit in regard to marijuana use and employee benefits is the question of, can medical marijuana, can the purchase of medical marijuana be reimbursed through something like a health savings account or a flexible spending account? And the answer to that is no, and that's because it remains illegal on the federal level. So those tax-favored arrangements and reimbursement accounts are governed by federal law, and because medical marijuana continues to be illegal on the federal level, medical marijuana, even in California, is not eligible for that tax-free reimbursement via something like an HSA or an FSA. In terms of looking toward the future of federal policy, there is really broad national support for legalization. So according to a Gallup poll conducted in October, 60% of the national population favors legalization. So that's really a growing sentiment on the federal level. President-elect Trump has not adopted a definitive stance on the issue of legalization, but he has overall been a pretty vocal proponent for states' rights. So that means that he will very likely continue and pursue an agenda where he respects the states' rights to implement regulations as they see fit and either legalize or not legalize without making much movement on the federal level. His selection for Attorney General, however, has publicly taken a pretty tough approach to marijuana and is very anti-legalization. So with all of these things in mind, when we look at the future, we can think that it's going to be very unlikely that measures will be taken against individual states that do choose to legalize marijuana use in one form or another, but we will not see any move toward legalization on the federal level under this administration. So how do these pretty diverse marijuana laws impact an employer's ability to implement use and testing policies for their employees? In terms of drug-free workplace policies, despite the legal uses of marijuana that exist, particularly in California, employers can continue to adopt policies that ban marijuana along with other drugs and alcohol from the workplace. So employers are completely free to implement those policies where there's a zero tolerance policy, essentially. Violation of these implemented policies may also be grounds for termination, and that's true even where an employee uses marijuana for medical purposes. So as an employer, you can continue to enforce a drug-free workplace policy. Employers do need to be slightly more cautious when establishing a testing program. So pre-employment drug testing or testing as a condition of employment is permissible, but it must be administered on a fair and consistent basis for all job applicants. That means there's no cherry picking which applicant to test and which applicant not to test. It must be administered uniformly. Employers can also refuse to hire an applicant who tests positive for marijuana, even where the prospective employer, the applicant, uses marijuana for medical purposes. So again, that ties back to you can have a drug-free workplace policy and you can refuse to hire any applicant who tests positive for marijuana, even if it's being used for medical purposes. Conversely, employers are generally prohibited from drug testing their employees. So this is in contrast to what they can do in terms of testing applicants. They're generally prohibited from testing their actual employees, and that's true whether the testing is done at random or on a one-time basis. There's just this general prohibition, which tends to favor an employee's right to privacy, really. Despite this prohibition, testing may be permissible in some limited circumstances, and that is where the employer has reasonable grounds for suspicion of drug use. And what exactly constitutes reasonable grounds is determined on a case-specific analysis of the facts and circumstances. So there is no bright line test to determine whether or not you have reasonable grounds for suspicion to ask for a drug test from your employee. An accident on a work site is not in and of itself reasonable grounds for suspicion. So if there is an accident that occurs in the workplace and you want to administer a drug test to an employee or employees that were involved in the accident to determine if they were under the influence at the time, you need more than just the occurrence of the accident to be able to lawfully ask for that drug test. So the accident is not in and of itself reasonable grounds. It's just part of that larger case-specific analysis. San Francisco has an ordinance that exceeds this reasonable suspicion requirement, and it actually has 2 additional criteria that need to be met before an employer can drug test an active employee. And that is, 1, that the employee work in a position where an impairment presents a clear and present danger to themselves, to their fellow employees, or to the public. And 2, that the employer provide the employee an opportunity to have the sample tested at an independent lab and have the opportunity to rebut the results. So if you are a San Francisco employer, there is a heightened standard for you to meet before you will be able to lawfully drug test an employee. Now, there are, of course, some industry exceptions to this general prohibition on testing of employees. So commercial transportation, that is governed by federal law that dictates when and how testing is to be done. Of course, that's in the interest of safety. And then any industry that uses hazardous equipment or materials, again, out of an interest for a safe work environment, for employee safety, and for public safety, these circumstances allow for more frequent testing. A few additional considerations about workplace policies and testing. First, employees with substance abuse problems. So employers that have 25 or more employees are required to provide reasonable accommodation to an employee who voluntarily seeks treatment for substance abuse, so long as that accommodation does not place an undue hardship on the employer. In this circumstance, time off may be considered a reasonable accommodation, so time off to allow that employee to seek treatment for their substance abuse problem. While that employee is receiving treatment, adverse action cannot be taken against them in regard to the substance abuse problem. So it's really important to know that if you're an employer with 25 or more employees, do be aware of your obligations to any employee who voluntarily seeks out treatment for a substance abuse problem. In terms of prescription drug use, employers do have a legitimate interest in knowing about prescription drug use that could endanger safety or impact an employee's ability to work efficiently. But any employer inquiry about prescription drug use, it must be clearly job-related and consistent with business necessities, such as those tailored to safety-sensitive positions. Sorry about that. I think we have some shuffling around the slide deck. Sorry. Okay. The use of prescription drugs may be considered a reasonable accommodation, so it's important to keep that in mind. Under the ADA and California's Fair Employment and Housing Act, an employee with a disability is entitled to reasonable accommodation for a disability, and in some cases that may include permitting an employee to use prescription drugs in the workplace. A really common example of this is a diabetic employee who may need to administer insulin while they're on the job. So as long as these accommodations would permit the employee to keep performing their essential duties, and as long as it doesn't endanger the employee themselves, other employees, or the public, that prescription drug use would probably be considered a reasonable accommodation. However, there's kind of a big caveat here. An employer is not required to accommodate an employee by allowing him or her to work under the influence of medical marijuana, and that's despite the fact that California legalizes the use of medical marijuana. So again, this goes back to the idea that despite the existence of rather friendly marijuana laws, especially in California, employers still have the ability to enforce drug-free provisions in the workplace, and they do not have to allow the use of medical marijuana by their employees. So the key takeaway here from this discussion about the laws governing marijuana use is really that California has very friendly marijuana laws. Medical marijuana has been around for quite some time, and recreational marijuana is now legal. Other states have similar laws, but despite these laws, employers are not prevented from implementing and enforcing drug-free measures in their workplace, of course, within some boundaries. All right, with the legal framework in mind, then I'm going to turn it back over to Michelle to discuss designing your program.
Thanks, Deborah. Yeah, I'm going to talk about a little bit about the how and why of putting together a drug testing program and a drug and alcohol abuse policy. So the cost of substance abuse is something that can be very significant to an employer. According to numerous statistics, drug and alcohol abusers in the workplace account for increased absenteeism, on-the-job injuries, lower productivity. And so all of these things can be an increased expense to your business. Employees using additional sick leave, other employees having to cover them, so overtime pay costs. You may have additional insurance claims on your health plan. Tardiness, workers' comp claims, overall just poor decision making, and it could be possibly damaging to your business's public image. So for these reasons, businesses may choose to have a policy that addresses the use of drugs and alcohol. While a smaller business will rarely have an all-out substance abuse program, unless of course it's required by federal or state law due to your industry, you may want to adopt certain strategies if you feel they can be effective in fighting substance abuse in your workplace. Should you decide to have a separate written policy that addresses drug and alcohol in your workplace, you may also want to consider instituting a drug testing program and/or providing an employee assistance program. But that doesn't necessarily mean that just drug testing is right for you. Every employer is different. It depends on your industry, on your employees, and your search for talent, who it is that you're looking to hire. So let's discuss some of the pros and cons. So employers that do drug testing or want to do drug testing do believe that there are a number of pros to doing so. Deterrence, studies have shown that ongoing employee drug testing lowers the number of employees who test positive. Employees will also be less inclined to use drugs if they know it could threaten their employment, and heavy users often won't apply. Safety, whether an employee is operating machinery at a construction site or using a knife to chop onions at a diner, most jobs are safer when done sober. By conducting drug testing, employers are fostering a safe work environment for their employees and for themselves. Employers may also see reduced liability. An employee who's injured on the job or fired because of drug-related incidents will not be entitled to compensation and will be much less likely to file a lawsuit against their employer. By testing for drugs, employers are protecting their firms from liability and could be saving money in the long run. Along with that, greater production, fewer revenue losses for all the reasons we've discussed before. So there's plenty of pros to doing drug testing, but there's also some cons. So the first obvious one would be the expense. The average estimated national drug testing cost is about $38 a test. So for a company with many employees, the cost of drug testing can really add up. Many employers also feel that they are invading their employees' privacy by doing drug testing. They can be an invasion of privacy. Employees are not coming to work under the influence. So long as employees are not coming to work under the influence, many argue that employers should not care what an employee does on their own time. Additionally, some employers make someone observe the employee during the drug test to assure that no tampering has occurred, and that really can break down trust among employees and the employer within the workplace. It may also reduce your applicant pool. So with the majority of voters in California approving the legalization of marijuana, you should expect that testing would reduce the number of people applying to work at your organization. There's also numerous studies that make the accuracy and effectiveness of drug testing debatable. The American Civil Liberties Union argues that even a small margin of error associated with drug testing can make a really big difference. Drug tests also cannot generally differentiate between habitual and one-time users, so it makes the results possibly unfair. And I guess that's probably why many of you are dialing in today. When you know substance abuse is a problem and you don't want your employees coming to work stoned, you probably also don't want to get into your employees' personal business. And with pot now legal, that can be a bit of a balancing act. So prevalence, how many employers are doing drug testing? When the American Management Association first started polling employers on whether they subjected their employees to drug testing in 1987, the number was 21%. But by 1996, that number went up to about 81%. And that was really kind of the Reagan drug war. But that percentage has steadily declined through 2004, which is the last time the AMA did the survey, and the number was down to about 62%. But numerous less formal surveys now put that number at less than 50%. So, as Deborah had mentioned, if you're part of a transportation or other safety-sensitive industry that are regulated by federal agencies, then, you're doing it as part of a regulation. But for private employers, drug testing rates really have fallen, and so the majority of employers have policies, but they're not necessarily doing testing. So if you are thinking about adding a drug testing program, or you just want to update your policy or consider what you're doing, there's a few things that you're going to want to think about as you're determining your approach. And the first, outside of government mandates that we previously discussed, there is no law that says you have to have a substance abuse policy or that you do any testing. It's really up to what you want to do based on the type of business you have and your employees. So the first thing to consider is, why do you want a policy? Is it that you have zero tolerance for drug use? You don't want anyone under any kind of substances when they're in the workplace. Or it could be that your industry or clients require it. It may be that you just want to maintain a workplace that is safe and productive. Or fourth, you don't really want to enforce a drug abuse policy, but you want to make sure that you have some options. Everybody should probably have some sort of policy, but to what level you want to test and who should be tested is really determined by what your employees do. So determining your approach, when is it appropriate to test? Deborah discussed the legality a bit earlier. Outside of random drug testing, which is extremely limited in California, how you test and what you test for can be somewhat determined by the nature of your business, as long as you are consistent and you're doing it consistently throughout your organization. So some employers do it during pre-employment screening. They make that part of their screening process. They may also do it as part of a physical examination if they have a labor pool that they need to do physical exams before they start. Most employers, though, it falls under kind of reasonable suspicion, or during post-accident testing. Something happened, they go to the clinic to get treatment, they do it then, or like we had talked about, random testing if you're part of a safety industry. But if you're looking to add a new drug testing program, you should consult with an attorney that has some expertise in this area and that can guide you. Another kind of point to this is that drug testing records must be kept separate from your employee's personnel file. So whatever you're doing here, you need to keep it separate from where all their other work-related information is being kept. Finally, when you're considering your approach, you want to look at what you're willing to do with the test results. And this is really, it might sound good to have a policy, but ultimately, what do you want to do when it happens? So, you may say, hey, I have zero tolerance for this, so I'm not going to hire any new candidates, and if I find that current employees under the influence at work, I'm going to fire them immediately. You can. That is your right as an employer. But more employers kind of want to give employees a second chance in many cases. So should you find that someone has a drug or alcohol abuse problem, you may want to give them time to get help. You may provide them with resources to get that help, guide them as to where to go, or even volunteer to help pay for employees to get help. There's no law that says really that you have to do these things outside of reasonable accommodation that Deborah talked about. So it really kind of depends what your take on this as an employer is. Or maybe you think, ooh, nothing. I don't want anything to do with this. I don't want to get into an employee's personal business unless it really affects my business. And that's also a very, very valid choice. The key is that you think about through worst case scenario when you're putting together your policy, and make sure that your management team is all in agreement so that you can be consistent before putting the work into diving into what your policy will look like. So when you're crafting your policy, there are kind of a few steps that you want to go through. Whichever way you want to address drug and alcohol abuse, you should have a written policy, though, of some sort, just to give yourself some options, again, considering kind of that worst-case scenario. And we're going to follow up, like I mentioned at the beginning. We have 2 sample policies that you can take a look at. One is a little more laid back and doesn't call for any testing, and the other is much stricter and does require testing. So you'll have a couple samples to really work with. Here's the thing, there's a ton of sample policies out there that you can use to work from, but you probably shouldn't just adopt a policy that another company uses. You really want to customize it for your organization. So the first thing that you'd want to put in your policy is explain the reasons for the program. And so why do you think that this is important? What are your concerns? Define your terms. What is abuse? What do you consider drugs? What do you want? Who do you want them to talk to? Who do they report to? And what are the consequences of violations? Is this a warning? Do they get a chance to get treatment? Will they be terminated immediately? And have a person that is responsible for program enforcement. And so this is a really good idea, is to have someone that is experienced in this, that understands legality, and so they can kind of make sure that the organization overall is implementing this policy consistently. And then you may want to conclude your policy with a list of resources. So any assistance programs, your EAP resources, all of that kind of thing, where they could get help. As you're considering what your policy should be, you also want to think about some things that happen within your organization. It's one thing to say, hey, no use of drugs or alcohol while you're at work. But you may want to also consider, what about your salespeople that aren't necessarily in the office, but they're out there entertaining clients? What are the rules for them? Maybe you have socializing among coworkers in the office, or a manager takes his team out and they go to dinner and they expense it. If they're allowed to drink alcohol there, you may want to not say then absolutely no drug and alcohol. It may want to be more about being under the influence and that sort of thing. What if you serve beer on Fridays at your office? You've been doing it for years. The question now becomes, can employees now smoke pot? Pot is legal, just like alcohol is legal. What are going to be your rules about that? Are the rules different for smoking a joint, which is, everyone can smell it, there's smoke in the air, versus maybe using a vaporizer where nobody can smell it? So what are your rules going to be on all of that? And then are you going to have different rules for different states if you have employees in different states? So all of those things need to kind of be considered when you're looking at putting together your policy. And this is really new territory for everybody. And what's considered reasonable is evolving very, very quickly. And so as you're putting together your policy, you definitely want to kind of customize it for your organization. And if you are going to put in a testing component to it, you're going to want to definitely do that under attorney-client privilege with an attorney that is experienced in this sort of thing. Part of this also is working with your providers. So it's not a good idea to necessarily have a drug testing policy that's kind of sitting out there all on its own that doesn't really reflect the process of the provider that you're going to use. So you want to have a written agreement with any providers that you use to ensure employee privacy and compliance with state laws. So whoever's going to do your drug testing for you, you should have a written agreement with them. Your policy should reflect the logistics and the process outlined by your testing provider. So whatever the process is, the timing, who transports them, what the decision making is, what happens after the test, all of that should reflect the actual process. And your policy should probably also reference current benefit providers and local resources so that they know where they can reach out to get help. So when it happens, unless there is some sort of accident, testing current employees tends to happen under reasonable suspicion. This is generally because someone is acting strangely and upon a closer look either smells or looks intoxicated. The key is that you want to show that you handle this in good faith. The first thing is, if at all possible, handle it privately. Try not to embarrass the person or make a scene. If you test, your process should be really clear about what your process is. It should be outlined in your policy. There shouldn't be a lot of decision making to do. But if you don't test, you want to show that you acted in good faith on the valid belief that the employee was under the influence. Because here's the thing, you're not a doctor. Well, most of you probably aren't. There might be a couple doctors on here. But either way, you're not going to know definitively the cause without a test. So if you don't do testing, what you want to do is you want to focus on the problematic behavior rather than the expected cause. So saying, hey, I think you're drunk, or I think you're still hungover from last night, isn't necessarily the best way to handle it. What you want to say is, hey, I don't like how you're acting right now due to this reason, or behavior that your coworkers have observed, and really focus on that. You may also want to get written statements from witnesses if possible. So right then, that day, what they observed and how it was, again, that you were acting in good faith. Some other best practices with this is that you probably want, if you're going to have a policy where you're going to have testing or discipline employees if you believe they're under the influence, you want to provide some kind of manager training on what reasonable suspicion is. So you could have, what is reasonable may totally depend on age, life experience, that sort of thing. And so ultimately, it might be better if you have kind of one expert. You have a decision maker who oversees this policy and will decide, whether or not you're concerned about somebody being under influence, do they need to be tested, or do they need to be sent home, so that it's handled consistently. You want to treat the immediate circumstances as a safety issue. So if somebody's ill or unconscious, you're going to want to call emergency services. You're going to want to send the employee home, but don't ever let them drive. Make sure that someone will get them home safely. Discuss the issue in terms of it being against company policy. So again, you're not a doctor. You're not deciding what it is that they took or what substance they're under. You're just saying, hey, I don't like your behavior. I'm concerned that you're under the influence. That is against company policy, and so therefore this is going to be our result. And understand that the issue might require reasonable accommodation. So, a real good point here is that if someone comes to you and they say, hey, I have a problem and I need help, and you are over 25 employees, you providing them time off or some other accommodation to let them get the help that they deserve or they need would be considered reasonable accommodation. But if there is really a behavior and a performance problem, you are not necessarily required to allow them to have that time. It really becomes a performance issue. And so that's just part of your policy and thinking ahead as to what you would want to do in that circumstance. All right, on that note, I'm going to turn this over to Dr. Lana Burkhead. She's from Physicians Medical Group, and she's going to talk to us about the technicalities of doing drug testing.
Good morning. Thank you for the introduction. And I'm just going to touch once again a little bit on the drug screening process and some of the mechanics of it. Just some definitions to start. When I use the word drug, I'll be referring to illicit street drugs or legitimate drugs that are being used for recreation or for other non-prescribed purposes. Substance abuse is defined as the continued use of a substance or misuse of a substance with negative consequences. And addiction, I just wanted to emphasize, is a chronic relapsing brain disease. It is a disease that is characterized by compulsive drug seeking and use despite harmful consequences. So what's the scope of the problem? How prevalent are these issues? This is information from the CDC. The scope of drug abuse in ages 12 and over, the use of any illicit drug or substance in the last month. In 2002, that was reported as 8.3% of the population in those over the age of 12. And in 2013, that is reported as 10.2%. That's a lot. That's 1 out of every 10 people has used something in the last month. We'll compare and contrast this to alcohol use, binge alcohol use. In the middle of the slide there, in 2002 and 2013 is approximately stable at 23% of the population. And heavy alcohol use is the same, about 6% of the population. And once again, those are pretty substantial numbers. With binge alcohol use, you're looking at 1 out of every 4 to 5 individuals. With heavy alcohol use, 6 out of 100. That's a large number of people. We'll contrast this a little bit with tobacco use, which is about, at this time, 25% of the population. 47% of high school seniors, based on data from 2013, report drug use in the last 12 months. And 22 million people over the age of 12 meet the criteria for drug abuse or dependency. And the most recent trend in this is the abuse of prescription opioid pain medications, and this is currently a national health emergency. Abuse and addiction of substances cost Americans approximately $700 billion a year. So this is a major issue economically as well as socially. So when somebody goes for a drug test, it's technically a drug screen. And when we use the term screening, what does this actually mean? The medical usage definition of a screening test is a test that's used in a widespread manner to determine the risk of having a particular condition. Generally, if the test is positive for what one is seeking, then it needs to be confirmed by more specific tests that can be more expensive or more invasive. An example of this would be in general medical usage would be PSA screening for prostate cancer in men. An elevated PSA level in the blood may indicate prostate cancer, but it can also indicate other benign conditions. And to determine the reason for the elevation, generally more testing is required. And the same principle applies to drug screening. A positive drug screening should be thus confirmed as such. How are the tests run? Most are done on urine via immunoassay techniques, which are rapid and are often referred to as point-of-care testing or bedside testing or point-of-collection testing. And these results can be available in a few minutes. Most private employers can test for any combination of drugs, but there are commonly selected panels that are commercially available in kits. And common test panels are a 5-panel, an 8-panel, and a 10-panel. But these can be crafted to your particular concern. What does a positive or a negative test result really indicate? Well, a negative test would be reported as such, but a positive test generally requires confirmation by a more specific and often more expensive laboratory method. And this is usually done by 2 different things, either through gas chromatography in combination with something called mass spectrometry, or through something called high-performance liquid chromatography. So why do we have to confirm a positive result? Well, the reason is there's potential for a lot of false positives. Commonly used medications can cross-react with urine drug screens and produce a positive result, when in fact the subject has not used any illicit substances. High blood pressure medicines, medications for depression, gastrointestinal reflux, allergy medications, seizure medications, all these things can cause a cross-reaction and a false positive result. And yes, poppy seeds can certainly cause a positive screen for morphine. In the event of a positive drug screen in the setting of cross-reaction, The final report, though, will generally report it as negative. When it's been determined that there's a cross-reaction, you won't get a whole list of what's been done and references to a positive screen. You'll just get a final report that just says negative. So why do we test the urine? Generally, drug screening is done on urine specimens because the window of detection is shorter than for blood specimens. And also, collecting a blood specimen is more invasive. It carries more risk for the subject and also requires more specialized personnel and generally, therefore, incurs more expense. A few more testing facts. Aside from a breath or blood alcohol test, drug testing does not determine impairment or current drug use. Rather, drug testing determines the presence of a specified drug or substance or its metabolite. And generally, for most substances, the window of testing is quite short, on the order of a few days. Is the drug of interest tested for directly? And this is not necessarily so. Many drug tests look for metabolites of drugs, and this is often due, once again, to half-lives. It's easier to detect the broken down product of a substance than the substance itself. And an example of this would be, for example, in a heroin user. When somebody uses heroin, this is metabolized into something called 6-monoacetyl morphine, which is then metabolized quickly itself into morphine. So a heroin user may only test positive for morphine, as the 6-monoacetyl version may not be persistent enough to be detected on a test. This chart right here, I realize it's a little bit difficult to see. It basically lists some medications that can cause a false positive result. And over to the right, it lists windows of detection for various substances, and generally they're on the order of a few days. So limitations for marijuana testing. Specimen sources for marijuana testing can include hair, blood, saliva, and urine. Smoking is the most common method of cannabis use, and with smoking, THC, which is tetrahydrocannabinol, which is the psychoactive component of marijuana, can be immediately detected in the blood. However, in non-habitual users, so somebody who does not use marijuana regularly, this time frame of detectability is only on the order of a couple hours to up to about a day. And the THC is rapidly taken up into the tissues of the body and then becomes undetectable. So generally, the active THC blood concentrations decrease rapidly after smoking due to this rapid uptake into tissue. However, in chronic users, THC receptors in the tissues can become saturated, and then this THC starts to spill back into the blood again. And therefore, in chronic users, this window of detection can then be increased, and that can be for as long as 7 days. So somebody could have smoked a joint 5 days ago, 6 days ago, and if they're a chronic user and haven't used since, they can still test positive on a blood test. A little more chemistry. The liver is the organ that metabolizes THC into its primary detected metabolite, which is something called 11-nor-9-carboxy-THC, and this is not a psychoactive component. In a chronic user, with more THC being spilled into the blood, you're going to have more processing from the liver of THC into the THC metabolite, and so the window of detection for the THC metabolite, which is then in the urine, is also longer as well. So the moral of the story is with chronic users, because there's more tissue saturation of THC receptors, the THC may be detected in the blood, and its metabolites may be detected in the urine for a prolonged period of time despite no recent use. So how do you determine if somebody's actually high? Whether or not blood levels correlate with acute THC intoxication is unclear, as it can take days for an otherwise healthy chronic marijuana user to drop their levels below the level defining intoxication, which at this time, according to some sources, is 5 nanograms per milliliter. So with chronic heavy use, blood testing for THC may be positive for up to 7 days, and urine testing for the THC metabolite may be positive for more than 30 days. That is a prolonged period of time. And what about a contact high? casual passive exposure to marijuana smokes, otherwise known as a contact high, is unlikely to give you a positive result. There is also lack of scientific consensus on what THC levels actually represent intoxication in either blood or saliva testing, which is another option for marijuana testing. And as we determine, urine testing may not correlate to recent use either. In addition, peak THC blood levels do not necessarily correlate with peak impairment. So therefore, impairment is really difficult to judge based on objective numbers alone. Hair testing is another option for marijuana use, but it's generally for historical use purposes, as a hair sample taken is unlikely to show a positive test result for a single episode use. But the hair can also then test positive for marijuana for up to 3 months in chronic users. It can be, you can run the test on any body hair, but again, it doesn't correlate or distinguish recent use or current impairment. And this is different from alcohol testing. Blood alcohol and breath tests correlate with recent use and with intoxication. Alcohol is metabolized quickly as opposed to THC, which can be found in tissues long after use. And also another issue clouding the situation is the DEA. The DEA still classifies marijuana as a Schedule I substance. So one is defined as having no legitimate medical use and a high risk of harm. Most positive drug test result standards are set by the feds. And if the feds are still classifying marijuana as a Schedule I substance, will they ever be able to set a value for acute marijuana intoxication? I apologize for the slide here. We're going to change gears here a little bit. And sometimes people, when they come in for a drug screen, will try to circumvent the drug test. And basically, the urine concentration of any substance depends a lot on somebody's individual metabolism, their hydration status, the frequency of use, the amount of use, their body composition. There's a large number of factors that can determine if somebody is going to test positive or not from a urine drug screen. And subjects will try to take advantage of this. They'll come in with excessively dilute urine from consuming a lot of water. They'll take diuretics to try to make the urine more dilute. Sometimes they'll try to ingest substances that may interfere with the assay itself, or they may even try to substitute a clean urine specimen. And this list right here just shows a few things that we try to look for when determining if a urine specimen provided is legitimate or not. So it's things like temperature and pH and concentration and things like that. So what happens at a drug screen besides providing an actual sample? And it's helpful to determine what a prospective or current employee may experience when they go for drug screening. These procedural protocols are extremely rigid, and having people understand what they should or shouldn't do prior to or coming into a drug test can actually reduce a lot of conflict with the test sites and make the entire process a little bit less onerous for everyone involved. We as providers absolutely wish to make this experience as convenient as possible, and having a well-informed HR department only helps us achieve our goals, and it also reflects well upon the employer. This is a list of some things that are parts of protocols to reduce tampering in urine drug screening, and it includes things like, having clients remove unnecessary outer clothing, requiring them to empty their pockets, having them not ingest anything at the test site that isn't provided by the staff, things like that. So in conclusion, substance use is quite common and costly to our society. Urine drug screens are the most common method used, and while generally accurate, there is the risk of false positives, and those false positives should have more specific testing completed to confirm those positives. A positive test does not necessarily imply current impairment, except in the case of alcohol breath and blood testing. Marijuana testing is complex, as it is metabolized differently than other substances of abuse. blood and saliva testing does identify the psychoactive molecule, but the level at which this causes impairment is debatable. And there are ways to attempt to alter or circumvent urine drug screening, so it's important to implement proper testing protocols. That concludes my portion of our webinar today. Thank you very much for your attention.
All right, thank you. We have a lot of questions and about 10 minutes left, so we will jump into a couple of them. One of the questions I got a lot was, what if they have a prescription for medical marijuana? And I think Deborah talked about that at the beginning. So in California, while it is legal in California to use medical marijuana, as an employer, you have the right to insist that they are not under the influence when they come to work. So that's a balancing act. If that's something that you want to test for before you hire or post-accident, but you have a right as an employer, whether or not they have a medical marijuana card, you have the right to insist that they do not come to work under the influence. Let's see, another question. If you offer to help one employee, do you have to offer in every similar circumstance? For the most part, if you have an employee that either tested positive and or admitted to you that they have a problem when you confronted them about, say, their behavior, if you're going to offer a reasonable accommodation, time off, access to resources, help them in any way financially, that sort of thing, you really need to be consistent across your organization and try to handle everybody the same. Now, do you have to be exactly the same in every similar circumstance? Not necessarily. I think it has to do with the behavior or the performance, whether or not they came to you versus you going to them, that sort of thing. You do want to be as consistent as possible, but that doesn't mean every single circumstance has to be handled the same. Work hours, especially coming out. A lot about if they have a medical card, prescription, under FEHA. Yeah, most of the questions are about if they.
I see one that has to do with recreational marijuana. So there's a question: can an employee use recreational marijuana during their break and then come back to work? Can policies be put into place which can avoid scenarios such as this? Absolutely. So back to that drug-free environment. If employees are taking their break, yes, you can't control what they do while they're on their break, but you can have that drug-free workplace policy that we were talking about, where you can say, while in the workplace, you cannot use any of these substances and you cannot be under the influence of any of those substances. So if that person comes back from work and they are under the influence and it's affecting their work, yeah, you have every right to insist that they not use recreational marijuana during their break. So you can kind of think of recreational marijuana in similar terms as alcohol use. Both are now legal with obviously some parameters. So it's kind of the same way as you might think if you have an employee who goes on their break and drinks alcohol. You may or may not know that they're doing it, but if they come back to work and it affects their work, then you have the right to sort of implement and enforce your drug-free policy.
We have another question that says, what if the employee refuses to be tested? So this is also something that should be outlined in your policy as to what the ramifications of that are. So if you have a policy that says, hey, if we have a reasonable suspicion or there was an accident that you're involved in that you need to go get drug tested and someone refuses to comply with that policy, then that would be, again, a violation of company policy. And so that is something that an employee could be terminated for. But it also goes back to being consistent. So having someone in your organization that kind of oversees who's being requested to be tested so that an employee doesn't feel that their supervisor is just picking on them, but it's part of an overall consistent policy that everyone understands. Deborah, any more that you're seeing? kind of apply to everybody?
There's a lot of very specific questions. I mean, again, there's a lot that relate to the medical use of marijuana, and I just want to kind of echo what we've been saying, which is even though medical marijuana is legal in the state of California as well as recreational marijuana now, as employers, you still have the ability to enforce a drug-free workplace and environment. And of course, you do have to think about providing reasonable accommodations to other employees, but allowing an employee to come to work and to be under the influence, even of medical marijuana, isn't necessarily a reasonable accommodation that you have to provide. So yes, you can still continue to enforce a drug-free workplace.
Mm-hmm. And then I think our final question, somebody asked, when would you recommend employers plan to make changes to their drug policy to address these newer upcoming marijuana legalization laws? Probably, this is a good time with most employers update their handbook in January, and that would probably be a good time to add some language around marijuana. Because, again, you may think that this is not an issue in your organization, but probably you do have some marijuana users because the majority of residents in California voted for it. And so you want to avoid the situation where, say, there's a group of you out to dinner and someone pulls out, their they pull out a vaporizer or something like that, and then, one manager takes that, really finds that completely inappropriate, and another one thinks that that's okay. You kind of want to overall, decide what your approach is going to be to this and make sure that your employees know.
Michelle, there's an important clarification that I want to make really quickly, and it's actually an attendee pointed it out about the question that I just answered regarding an individual or an employee using recreational marijuana on their breaks. So my answer to that question was kind of thinking that the employee leaves the premises to take their breaks. So maybe they go out for an hour for lunch, or they just leave for an hour or so and then come back. If they're taking their break on your company property, of course you don't have to allow them to be able to use recreational marijuana or any drug or alcohol. So you can still enforce that entirely on your premises. And then, of course, if they are leaving, you can't control what they do while they're outside of your premises, but you can make sure that their performance is not affected when they return. So I just wanted to point out that important clarification, and thank you for pointing that out.
Yes. Thanks, Deborah. All right. On that note, we're going to wrap this up. We have a number of questions. We will get back to you via email, either this afternoon or probably tomorrow. Feel free to send any more questions. And if you did have any trouble downloading the sample policies or the PowerPoint presentation, we will email that out to all of the attendees with their evaluation. So thank you, everyone. Have a great day, and hopefully you tune in again soon. Thanks. Bye-bye.